by NIT, AG, between Mr. Akin and Isaac, Babawale, Akin Tomiwa, and New Hope Agriculture and Technology. Parties are absent on the left.
Announce your appearance.
May it please my noble lord, W.A. Bello appears for the judgment debtor respondent.
Judgment debtor applicant or judgment debtor respondent?
Judgment debtor respondent, my lord. Appear for judgment debtor respondent, my lord.
Okay. Any other appearance?
Applicants. I'm very sorry, my noble lord. I'm very, very sorry for the applicants, yes. Judgment debtor applicants, my lord.
I know certainly that you are the one who filed the motion. You are the one who argued the motion.
I'm sorry, my lord.
You are now saying you are for the respondent. So I thought maybe you might have had a very good arrangement somehow, somewhere.
I'm very sorry, my
lord.
The
new position.
You just caught my attention to.
Very well. Any other appearance?
Respectfully, my lord, IP Arinze. IP Arinze, my appearance is for the judgment creditor respondent.
Very well.
Most grateful, my lord.
This matter comes up today for ruling on the two applications argued, and the ruling of this court is ready, and I'm going to deliver the ruling right now. Because of the nature of the applications, the content of the applications, the representation of counsel, and the unique position of the defendant judgment creditor being the only person. So I have decided to make a consolidated rulings. So the ruling will touch both sides. So this is the ruling of this honorable court in these two applications. The applicants filed two separate motions on notice simultaneously, both dated and filed on the 25th day of March, 2026, with identical reliefs, praying for one, an order of this honorable court staying execution of the judgment of this court delivered on the 12th day of March 2026, pending the determination of the appeals lodged against the said judgments. Two, and for such further or other orders as this court may deem fit to make in the circumstances. The motions are respectively brought pursuant to Order 17, Rules 1 and 4, Order 64, Rule 8, and Sub 1, 4, 11 of the rules of this Honorable Court 2017, and under the inherent jurisdiction of this court. There are 4 grounds upon which the motions are brought as stated on the face of the motions. In support thereof are a 15 paragraphs affidavit sworn to by the applicants. Annexed thereto is Exhibit A, being the revenue collectors received, dated the 25th day of March 2026, and written address containing submissions of council in support of the motion. A sole issue for determination to it whether the applicant is entitled to the discretion of this honorable court in the circumstances of these applications. In moving the motion, counsel for the applicants, Mr. Waliu Abiodun Bello Esquire of Primus Haven Attorneys LLP, adopted the written address as his argument, while adumbrating, counsel submitted that applicant has complied with the rules of this court, having paid the requisite fees to the registry of this honorable court for transmission of records of this court. Counsel submitted that submissions of applicants counsel. Counsel submitted that granting this kind of application is based on the existence of a special or exceptional or strong circumstances. Counsel cited Vaswani Trading Company against Savalaka and company citation captured, and quoted the views expressed by Coca JSC of the blessed memory on what would amount to exceptional circumstances in court for the grant of stay of execution. Counsel went further to refer this court to the case of Ajomale against Yaduat, number 2, citation captured of the report. More so, counsel referred the court to the Supreme Court decision in Anyao against Okwarofo and others, citation as well provided, where some circumstances are enumerated to be satisfied by which an application for stay of execution may be granted. Counsel maintained that it is opposite to state that the circumstances enumerated in the case are exclusive and not conjunctive in considering the application of this nature. Counsel went further to commend the case of Martins against Nikana Foods Company Limited, citation provided, where the Supreme Court granted stay that was earlier refused by the 2 lower courts solely on the ground that the issue was substantially arguable and in an area of law which was to some extent recondite, and where either side could have a decision in its favor. Counsel submitted further that from the abundance of decided cases and authorities, the court will grant an application for stay of execution in well-settled circumstances, which includes 1, where it was shown that the appeal involves substantial points of law, necessitating the parties and issues being in status quo until the legal issues are resolved. 2, where nature of the subject matter in dispute, whether maintaining the status quo until a final determination of the appeal in the case will meet the justice of the case. 3, where the judgment is in respect of money and costs, whether there is a remarkable probability of recovering this back from the respondent if the appeal succeeds. 4, the chances of the applicant on appeal are high. That is, if the chances of success are so high, then the order for stay shall most likely be granted. It is the submission of counsel that in view of the facts in support of the motion and submissions of counsel, applicants have disclosed facts special enough to warrant granting the motions by this court. Counsel posited that the applicants have pending competent appeal with arguable grounds of appeal, and the supporting affidavits show that there are special and exceptional circumstances. In the exceptions, this court in the applications, this court is urged to grant the motions in favor of the applicants. The Respondents' Council, in response to the motions, filed a 9-paragraph counter affidavit deposed to by one Ikechukwu Arinze, legal practitioner in the law firm of the Council for the Judgment Creditor Respondent, which is accompanied by a written address of counsel filed on the 2nd day of April 2026. In addressing this court, counsel adopted the submissions in the written addresses as his argument in opposition to the motions. 3 issues for determination were raised by counsel, to it: A, whether this application is competent in the absence of an entered appeal. B, whether the applicant has disclosed special or exceptional circumstances to warrant a stay of execution. And C, whether the respondent is entitled to immediate enjoyment of the fruits of his judgment. In arguing the issues above, counsel posited on absence of special or exceptional circumstances in the motions at hand, wherein it is submitted that a stay of execution is not granted as a matter of course, but only in exceptional circumstances. Case of Baswani Trading Company against Savalaka and Co. Supra, where the Supreme Court held that a stay is an extraordinary remedy. Counsel went on to cite Ali Bello against Attorney General of Oyo State, citation provided, where the Court of Appeal restated what would be necessary for the applicant to show for the grant, and that the said conditions are barren in the affidavit to meet up the legal threshold, and that the applicant has not placed before the court any credible or substantial grounds for appeal. Furthermore, counsel cited SPDC against Amadi, citation provided, where counsel stated that the court must consider whether the appeal is arguable and not frivolous. Counsel submitted that the present purported appeal is speculative and designed to delay execution, looking at the nature of the subject matter, which is a depreciating asset, which are motor vehicles, and that continued possession and use by the applicants will diminish the value irreversibly, alter the conditions, and defeat the substance of the judgment. Counsel cited Balogun against Balogun, where in which the Supreme Court held that a stay will be refused, where it will render the judgment nugatory. Counsel drew the attention of this honorable court that the applicants are in disobedience to the court order as they failed to return the motor vehicles. He cited the case of Milad, Lagos State against Ojuku, citation provided. Consequently, this court was urged to dismiss the application with cost. In further contest, the applicants had filed a further affidavit in support of the motions containing 3 paragraphs affidavit deposed to by the applicants, wherein it is stated that the application to stay the execution of the judgment of this court was filed within the period of 14 days, which this court ordered the vehicles to be returned to the judgment creditor respondent, and also that the sum of 3,208,380 naira transferred by the applicants into the Zenith Bank account number 10101461390 of the judgment creditor / respondent. In the whole, the applicants' counsel urged this court to grant the motions on notice. The court decision. In determining the motions before me, and indeed the issues raised as well as the submissions of both counsel, which I have carefully read through alongside the motion paper and every depositions for and against, and also attentively listen to counsel on both sides. The question that will be pertinent to ask is, has the applicant placed before the court sufficient materials warranting the court exercise discretion in favor of granting the motion? The judgment debtor applicants are dissatisfied with the decision of this honorable court given in favor of the defendant judgment creditor on the 12th day of March 2026, and therefore contended that they have appealed to the Court of Appeal, as such, filed the present motions or notice seeking for the stay of execution of the judgment of this court. The grounds for the motions are as stated on the face of the motion paper, that 1, the applicants having perused the judgment of this court dated 12th day of March 2026 has filed a notice of appeal against the judgment. 2, the appeal raises substantial and arguable grounds of law. 3, if execution is carried out, the appeal will be rendered nugatory. 4, the applicant is willing to abide by any condition imposed by the court. The applicant deposed 2 facts in paragraph 7 of the supporting affidavit. The grounds of the appeal as contained in the notice of appeal raised substantial and recondite questions of law, thus necessitating the grant of the application for stay of execution in this suit. End of court. And at paragraph 9 thereof, it is deposed that the applicant's notice of appeal contains good and arguable grounds of appeal with likelihood of success. End of court. The law is tried that stay of execution pending appeal is at the discretion of the court. This is a settled law which has received statutory backing in Section 47 of the NIC Act 2006, which empowers this court to either refuse or grant a stay of execution unconditionally or upon the performance of such conditions as may be imposed in accordance with the rules of the court. Order 64, Rule 10, Sub 1 of the rules of this Honorable Court 2017 gives the court the discretion to make or refuse to make an order for a stay of execution pending appeal. In consideration of an application for stay of execution, certain factors operate as guide under which the court exercises its discretion, such as the provisions as mentioned in Section 47 of the National Industrial Court Act 2006. Order 64 of the rules of this court contains provisions that regulate the granting of application for stay of execution pending appeal. Rule 13, sub 2 and 3 of the order provides thus, and I quote, where a party is dissatisfied with the decision of the court and seeks to appeal to the Court of Appeal, such a party shall, in the party's application to the court for stay of execution of the judgment or order, A, file a notice of appeal, B, pay for the compilation of the records of proceedings, C, exhibit certified true copy of the judgment or order the party is appealing against, D, exhibit evidence that the appeal has been entered in line with the appropriate rules or the practice direction of the Court of Appeal, and that there is a valid appeal before the Court of Appeal, and E, exhibit evidence that leave has been granted by the Court of Appeal where leave is required under either by law or by the rules of the Court of Appeal. Subrule 3 states, where all the requirements in Subrule 2 above have been satisfied, the court may grant or refuse to grant the application for stay of execution of the order or judgment of the court after taking into consideration the provision of Section 47 of the National Industrial Court Act 2006. From the content of the above provisions, it is crystal clear that before an application of this nature is considered and granted, the following must be satisfied. These, the applicant A must file, the applicant must have filed an appeal. B must have paid for and ensure the record of appeal is compiled and transmitted to the Court of Appeal. C, the appeal must have been entered in the Court of Appeal. And D, the appeal must be a valid appeal, requisite leave having been obtained. Evidence of these matters or instances must be exhibited to the application in addition to a certified true copy of the judgment or order the applicant is appealing against. The law is that these requirements are conjunctive and mandatory. Hence, Order 64, Rule 13, Sub 3 of the Rules of this Honorable Court 2017 categorically provides that it is only when the motion is competent by complying with the above requirements that the court can proceed to consider whether to grant or refuse the application. Arising from the aforesaid, let me detect whether the instant applications are competent. I have re-examined the motion papers along with the only exhibits A, which are the revenue collectors received or payment for records. I equally read over again the affidavits and recall the brilliant submissions of both counsel and the related same with the provisions of Order 64, Rule 13, Sub-Rule 2, but I am unable to find any application for leave proposed notice of appeal to the Court of Appeal, certified copy of the judgment of this court, or order upon which the appeal is premised, exhibited. In fact, all the requirements of the rules of this court regulating the application have not been satisfied by the applicants. Of course, there is no evidence of the compilation of the record of appeal or exhibit of certified true copy of the judgment of this court against which appeal could be said to have been filed. In the absence of these and many others, could I be right to be in the eye of the law to exercise my discretion to grant this application? Further to this question, is it safe to hold that refusal of the motions could render the appeal nugatory? My view is as to the risk of rendering the appeal nugatory. I want to recall that the subject matter of the appeals are motor vehicles, the source of which is from the judgment creditors. Where the appeal is successful, the motor vehicles could be retrieved. Thus, the execution would not render the appeal nugatory. In the circumstance, the applicants have failed to establish special circumstances that would warrant granting the motions. I find the applications unmeritorious, which must suffer refusal outrightly. Consequent upon this, I refuse to exercise my discretion in favor of granting these motions for stay of execution. The motions filed by the applicants in their respective cases seeking for orders for stay of execution pending appeal, having been found unmeritorious, be and are hereby dismissed. Parties shall bear their respective costs. This is the ruling of this court.
The court pleases.
As the court pleases, my lord, we've learned a lot from the ruling of my noble lord. We are very much obliged to the
Lord, we sincerely appreciate the well-considered ruling of the Honorable Courts, and we are glad for the court's time at this time. We understand how busy the court schedule can be. We appreciate, my Lord.
Very well. It's a consolidated ruling. It's a consolidated ruling. This ruling cuts across the two motions. That's why I'm saying it's a consolidated ruling.
As the court pleases.
The ruling of this court is ready at any time, at any point in time.
As the
Because
court
they have
pleases.
to register and collect the copy of this ruling today.
As the court pleases, my lord.
As the court pleases.
Any other matter? But only.
Of the law.
Call the next case.
And title and events of education.
Professor Council Abisuya, I did like you. Are you online? Please kindly signify so that we can see you.
Has he joined us?
But people, let us hear. Tell her to record.
Inquire if she is is her name there?
I know it's there.
Yes.
But the claimant is present. Defendant is represented by the names of Mr. Ogunbanjo. Ololade. What is your position with the defendant? Just to play registrar.
Can you announce your appearances?
Ayurindi,
Ayorinde,
Akinboyo,
Ayorinde, Akinboyo. Yes.
appear with Uganda, a rebel. Rebel is E-R-E-B-O-R.
With over respect to the Lord,
Yes.
my name is Adetunji Muraina.
Adetunji.
Adetunji Muraina.
How do you say Brano?
M-U-R-A-I-N-A.
Oh, Muraina.
Yes, my Lord.
Yes.
My Lord, I will here with T-E. Ogunbanjo. T-E. Ogunbanjo. My Lord, our appearance for the defendant.
What is the position of this case today?
My Lord, the matter is for co-examination.
Are you ready?
Yes, my Lord.
Can we get across to the witness? Counsel for the claimant. Yes, why the witness? But she's not responding.
Yes, you should have please. I cannot see her. I cannot see her, please.
Hmm? What can we do now to know that CW1 Professor Faustat is with us? Prof, is Professor Faustat with us? I can see her name is there. She's invisible.
Professor Adenaiki, please. I want to see your face. Please put on your video.
Okay. Hello, good afternoon, sir.
Good afternoon. Are you with us?
Yes, sir, I'm here.
We have joined us. Register.
Yes, my lord.
Please take us through and
Professor Adenike, can you hear me?
Yes, I can hear you now.
You are hereby reminded that the last you are hereby reminded that the whole truth is still subsisting. So you have to say the truth and nothing but the truth.
in the course of the cross-examination.
Because of the cross-examination. Did you get that?
I can't hear you well. Please, can you repeat yourself, sir? Please.
You are hereby reminded that you are still on oath and you have to say the truth and nothing but the truth in the course of the cross-examination.
Okay. Noted.
Yes, sir. Well, the witness has been reminded.
Counsel? Now, Counsel, as
Yes,
we
sir.
have done, you are in court where you watch the previous proceedings. So let's be guided by that technique. Can we do that? You will need not more than 20 minutes for the cross-examination.
This one is virtual.
It's virtual. Okay, I give you 25 minutes. 25 minutes, that will, it will be ending up at what time? Now it is almost 12:15. So if you can have some 20 minutes to 1, 20 minutes to 1, you will be through. Okay.
Professor Adenike. Professor Adenike.
Yes, sir.
Professor Adenike. Are you with me?
Yes, I'm with you. It's only that I can hear just silently. I don't know, but I'm with you. I don't know why.
Now, your appointment with the university is in accordance with the law of the university.
With the defendant.
Your appointment with the university is in accordance with the law. That is, your appointment to the university is a statutory one. Hello.
Hello.
Your appointment with the university is a statutory one.
Okay.
Confirm. Yes or no?
I'm what, sir?
Your appointment with the defendant is in accordance with the law of the university.
Okay. I can hear. My appointment with the defendant
is
in consonance with the law of the university.
Yes.
Okay. Yes. Yes, sir.
Okay. Apart from the law of the university, there is still governing rules of university. Are you aware that you have
Apart from what?
Apart from that, the law of university, there's law of university that is staff senior condition of service that you have tendered before.
Apart from the law binding on me,
Yes, there is a procedure, there's a working procedure of university.
Yes, there is. And there is a procedure which we have to duly follow.
Yes, this is already an
Yes.
Now, it is not all cadres of lecturers in university that are entitled to sabbatical leave. Is it?
Is that what?
Sabbatical leave. It's not every cadre. Assistant lecturer, lecturer 1, lecturer 2.
I really hear what you are saying, and I put it as speaker. I really hear what you are saying, and I put it as speaker. What do you say about sabbatical leave? Hello? Hello?
Can you hear that?
You said what? Please repeat yourself. I'm sorry. I don't know what happened though. It's the network. I really hear. And I put it at the peak of the speaker.
Can you hear me now?
Yes. You can talk now. Let me see.
Can you hear me now?
Yes. I can pick small. Say something.
So you can hear me now.
I can pick you small. You can say something.
Is something wrong with your system, Council?
I don't know. It's a speaker.
But
I
but
don't know.
I can hear the witness.
So you can hear me now. You can hear me.
Yes, I can hear you. Say something. I'm picking it small.
Okay. Sabbatical.
Yes.
It's not for all lecturers in the university, all level of lecturers in the university.
I know.
Sabbatical.
I know. You have to reach a certain stage.
Okay.
Mm-hmm.
Yes.
The stage are senior lecturers and professors. That's all.
Okay.
Confirm. That's true. Is that true?
Senior
lecturers and professors that are entitled to sabbatical.
Yes. I think I should say professor and professor.
Yeah.
Yes.
Before you can be given sabbatical leave, you have to apply in person.
Which I did.
Yes. You have to apply.
Yes, which I did. Yes.
You apply for the sabbatical leave. You apply.
I did. I applied. I applied after a long due. After having spent 29 years, I applied once.
You applied. Say you
yes.
shall apply.
I applied. I applied.
The granting of the leave is not automatic.
The what?
The granting of sabbatical leave by the university is not automatic. The moment you apply, we have to give you. It's not automatic.
I cannot say that it's not automatic because you have to spend certain.
Is it automatic or it's not automatic?
It's automatic at a certain level, which I've reached.
You file an application now.
Yes.
University has discretion to grant it or not.
Oh. They can grant it based on the recommendation from my dean and my HOD.
And they may not grant it.
I know. I don't know that.
No, answer.
She says she doesn't know that.
Okay.
Yes.
When we applied for the sabbatical, the university granted it.
Yeah, they granted it.
Yes.
When it was granted,
Mm.
it was granted on bond.
Yes, it was granted on bond.
Yes.
And the bond, and you sign an undertaking to that effect.
And what?
You sign an undertaking with the university to that effect.
Yeah, which I did, yes.
Yes.
After you have been granted leave, I mean sabbatical leave, it used to be 1 year.
Yes. But at times, they normally extended it.
No, it used to be
Yes,
1
we
year.
have precedents. It's
The
1 year,
tradition
but
is-
they normally extend it.
Your
We
own
have
case,
precedents.
wait, in your
Even
own case,
during our period,
1 year,
those
you are
that we
granted
went
a year
together,
sabbatical leave. In your
we
own case,
at times there are precedents. They normally extend.
Counsel,
Yes.
take it easy so that she can understand you, you can understand her. You can, it's not easy as you are talking, she who is talking, you cannot know, and even the court is left at a crossroad, we cannot hear both of you. Now the question is, after you are granted leave for the sabbatical leave by the university, it
Yes,
used
sir.
to be for 1 year, is that right?
Yes.
And you are trying to say something.
I said, she said, he said it's only for 1 year. I said at times there are slight changes. They normally extended for people, which they did for some people during our time. They extended for them. So at times they shift band.
Wait, it's okay. But in your own case, it was not extended.
Can I let me talk here?
No,
we came. Let me talk. Let me say something. My lawyer. Let me talk here. Let me. We came. I resume. Let me talk, sir. You asked a question. Can't I should be able to reply you, sir.
Please, I want to protect me.
Please.
Extended or not.
I'm sorry. That's the way I think I can reply you. Yes, I resume before the actual time. I resume before the actual time.
Prof.
Yes, sir.
Prof.
Yes, sir.
The questions are serially asked, and your answers are well said. What he asked lastly is that, was it extended in your own case?
No, not really. We asked for extension, and they didn't answer us in time, and that is the usual deal there. You must have gone on something before you get your letter. So that is why.
Not extended. Your own was not extended.
Mm.
One word. Your leave, your sabbatical was not extended.
I didn't receive their reply, Sha. I didn't receive their reply.
Yes.
Your sabbatical leave expires on 2nd of October 2023, and you did not resume at that date.
I did. I resumed. Even I resumed earlier. I resumed earlier because we have already closed for session where I was, and I came back to resume. And I filled a resumption book. I resumed earlier than that, sir. And I was given acknowledgement for my resumption.
Yes.
Yes. Took a leave of absence from the court on from the university on health ground.
I did what?
When you resume,
Yes.
before the due date, you took a leave of absence from university on health ground.
Yeah. You know, I told you that normally they normally extended. I met with the VC. He said he will grant me on net grant because then I was using stick. I was using stick to work.
So
I had a health problem. Yeah?
You took leave on health ground.
On net grant.
Yes.
I took leave on net grant. I mean, when I came back from that sabbatical, I went to VC. I went to VC to tell him, and he saw me, and he said I can go and write leave of absence without pay. I met with him personally.
Has she answered you? Are you satisfied with that answer? No, I think what she said.
Yes.
You asked this question. You took a leave of absence on health ground after you resumed.
I applied. You know,
verbally. She said yes. She said yes. I took leave on health ground as I met personally with the VC.
Okay. Okay.
That's
sir.
what she
Thank
said.
you. That's what I said. Thank you, sir.
That time you have taken leave, you have not resumed back to the university.
I did. They can check their book. I have my letter of resumption, acknowledgement.
It's okay, it's okay.
Yes.
You will serve the university for how many months after your resumption?
How long?
How long you serve the university after your resumption?
You said what?
After your resumption.
I can't hear you, sir.
You said you resume.
Yes, sir.
Then you serve the university for how many months? Or how long?
I resumed in August, and I left in. I resumed in August, and I left in October, based on what my discussion with him. Because I have to go for the medical for the leg.
It's okay.
Which year is that?
Which year was that?
That is 2023, sir.
Yes.
When you resume, when you are on sabbatical, the procedure and the rule is that you will serve the university for a year. After return, you serve the university for a year. That's the procedure.
Yes, that is procedure, and that was what warranted the bond. But on health grant, nobody can be employed and have any health challenges that you cannot be considerate for. She saw me. I was working with stick, and he even said, because of your health challenges, even the registrar, they saw me. You can be granted. Go and write it. That was what I was told, and I wrote the letter.
Yes.
When you continuously absent yourself after that sabbatical leave, the university wrote a letter to you And
When
that
I did
letter
what?
is dated 10th of October 2025.
Please repeat. When I did what, sir?
University,
I'm sorry.
when you failed to, thereafter, the university wrote a letter to you, dated 10th day of October 2025. It is that you failed to resume.
2025.
Yes, 10th October 2025. If you are in court, the letter is here.
How could that be 2025? Maybe they want to write 2024.
2023, sorry,
because,
it's the right 2023, sorry. 2023, sorry.
They dismissed me then. They continue writing. And whenever they write, immediately I reply that because of it, I cannot travel because of the leg. They've done the surgery then. I told them that give me ample time. I'm ready to come and resume for my duty when I'm fit. I wrote them back severally. Okay. But the investigative panel almost every other day normally writes me. And I even copied the VC that this is what I've been receiving from investigative panel. I'm not fit to come now. Just give me time for the healing to take place.
Yes.
Now, if you are seeking for leave on edge ground, there are procedures in university rules. That is, by virtue of there are procedures in the university rule that you have to follow.
Yes, sir. There are procedures, but on this time around, I had a one-on-one discussion with him. He said that I can go on leave of absence without pay. So that what warranted leave of absence without pay? Because
you did not comply with the procedure.
For leave of absence, if you want to go for leave of absence,
ground, you are seeking leave.
He didn't say that she would do. He said go and write leave of absence. This time around, because I'm not going to be paid, he said go and put up a letter for leave of absence, which I did.
It's okay. I'm waiting for a report. I'll ask questions.
Yes.
If you are seeking leave of absence on air ground from the university, by virtue of SBC 19, that is SBC 19, which is the senior staff condition of service that you said you are aware of. You are supposed to go through the X. You are supposed to go through the university X bill.
Excuse me, sir. It's because all this. Excuse me, sir.
Leave on air ground. You first got to complain with the air ground. They will investigate whether you are fit or you are not fit. The X Department of University.
Excuse me, sir. It's because you are a lawyer. It's because this thing now. It's because this thing now. 19. It's because this thing now turned around. That time it was not like that.
That is what is
he said, go and write. How will I go and take a condition of service? When we talk on one-on-one on a good platform, it's because this thing now came around that you people are using that for me. I won't say for us. It's because you are doing at that time that I met with him and the registrar. It was not like that. We talked on a platform of peace.
Okay.
And I went ahead to write. Me that was in pain.
It's okay. It's okay. Is the vice chancellor and registrar the owner of the National Investor of Education?
At that time, is the headship, is the leader there that will take it to council. So once he says something, I should be able to believe in him.
It's okay.
Yes.
Do you know a body called Joint Committee of Senate Council and Senate on Staff Disciplinary Matters? Do you know that body? You know that body?
Joint committee.
By then,
Committee of Council and Senate on Staff Disciplinary Matters.
Sir, by then, there is nothing.
Whether you know them or don't know them, that's all.
I don't know them. I don't know who are the people comprises of the committee.
But you know the
I don't know them.
body. People comprises.
I don't know them.
You know Joint Committee of Council and Senate on Staff and Disciplinary Committee. Do you know that body? Not the members.
The body is there. The body is there. The body is there. Academic matters, disciplinary committee, all are there.
Yes.
Do you know the body called Staff Investigative Committee on Ethics and Discipline?
Yes, now I told you they wrote me and I replied them. Their secretary normally writes me every other day. They normally write me every other day to come.
Investigative Committee.
Yes, they are the one that wrote to me. Yes, they wrote to me severally every other day, and I reply every other day. Immediately I received their letter, I reply, telling them I'm on my health ground. I won't be able to come now. Please, I pleaded for reconsideration. They should go and look for all my letter. I pleaded that I cannot come now. I cannot come.
You have appeared before. Sorry,
yes.
You have appeared before. There are several invitations. There are several invitations from this Staff Investigative Committee on Ethics and Discipline. And
there are what?
Staff.
There are what?
This body called Staff Investigative Committee on Ethics and Discipline. I wrote several letters to you inviting you.
Yeah, that's what I'm confirming. That's what I'm confirming to you. Okay. They wrote, and I replied that they should give me time, that I will come when I'm fit, that they should please consider me on next ground. Yes, I didn't deny that.
Yes.
And then, have you resumed the university? You resumed?
And that is all that because I didn't appear, because I didn't come.
Whether
at that period.
After do you resume back to the university?
Which resumption again?
Did you resume back?
I resumed in August, and I left in October 10. I told you.
Thereafter.
And they wrote me October 11.
No, wait. August, October.
Yes.
That's the August, September, October. Thereafter, did you resume back to the university?
I didn't, because all this leads to dismissal. They didn't give us time. When we asked for a reply of our letter, they said we should give them time. They should give them time. December passed, March passed. In April, they now gave me dismissal. So this metamorphosed to dismissal. When they stopped even my sabbatical leave, they didn't pay me. They didn't pay up to tax. They stopped salary. Then we came around. They stopped since July. They didn't pay up to a year. It lead to dismissal. So
Down by you are using my time.
I'm listening, sir.
Now, when thereafter you have attendance University of Gambia. There are attendance record for you at the University of Gambia.
I don't know that. It might be formulated because of the woman. The woman is collaborated with the VC. I know what was going on. Even our resumption there for sabbatical, the woman started with us just a month. A month.
Data is here from the Gambia.
Yes. Maybe they fabricated it. I didn't know anything about it. If there is a letter like that,
what are the signature?
It doesn't matter. It doesn't matter. The woman was there. The woman that was the cause of all this thing was there after our dismissal. She can do anything. I didn't know anything about signature. They fabricated it.
Yes.
The last question?
Yes.
Yes, you said you had two and you have asked one.
If going by the university rules and letters and several correspondence against the lecturers, you are supposed to use your accumulated leave or your expected leave during the academic year. You cannot defy it.
When did they start that? Maybe they just started.
Is there your rules? It is there.
No, sir. I have the letters with me. They don't allow us to go on leave.
19.
Yes.
She's supposed to utilize all leave, all working leave.
When we like use it, when we are not granted allowed to go, when we finish the exam, we will mark, and they will ask us to resume. They are the one granted it, and they will accumulate it and give us letter. I have 480 days working leave. They didn't allow us to go on leave.
Hello.
You can ask anybody.
Let her learn first. Yes. What do you want to say, Council?
Hello. All the leaves.
He wants to say something.
This for examination.
Yes, but let me take him. What do you want to say, Council?
No, my time will pause, please.
Yes.
And he's asking about the content, with respect to that set of law. And I expect that he should point to that particular provision.
That is it. If you want, Council, the document is already in evidence before the court.
Yes, my lord.
If you want to ask any question as to the content of that document, you want to get some response from the witness, then you do the attention of the witness to the particular area.
Hello. Say you are with me. Hello.
Hello, I'm here. Hello. Hello.
By virtue of chapter 6, paragraph 621 of exhibit C19.
What is the exhibit?
This senior staff condition of service.
Mm-hmm.
You are supposed to use all your leave.
When?
Your academic session.
You should have asked them there if they allow lecturer to go on leave.
You are supposed to use it.
When you ask, they will ask us to resume. They are the one granting accumulated leave. They don't allow us to go. We don't rest. When we finish a session, we mark and we resume instantly. If they start that one now, maybe they start after our dismissal. I have the letters. They normally upgrade each leave to another leave. That is why I have 480 days. 480 days. Even it's because I've taken some for medical issue then that made it to reduce to 400. It was 560 something before. They don't give us leave. We don't rest in Southwest. It might be in their condition of service, but it wasn't like that. They work clockwisely. We don't rest as lecturer. Go and sample people's opinion, unless if they want to lie. I have my evidences with me. My papers are with me. They will say, you go and defer, go and defer, go and defer. We normally defer legal. If they start that one now, it's just now that they started.
Finally,
when you finish your leave, you're supposed to serve university for a year and 6 months.
Mm-hmm.
That's what's obtainable everywhere, including your own position. When you finish your practical, you're supposed to serve university for a year and 6 months.
Mm-hmm. Yes.
That's the procedure.
That is, I told you earlier on.
No,
that is the. Let me talk now. You ask question.
When you finish your sabbatical, you are supposed to spend a year after your sabbatical.
That is the rule. I said I came on 8th grant.
Yes, 1 year.
I said I came on 8th grant and I met with the VC. He saw me. I came on 8th grant. That's why when the Gambian school closed the session, I left there in time to come back for me to do the next procedure for my leg, to come and talk to them to see me how I was. And he saw me. He said, on your 8th grant, I can grant that one and I will take it to council. It's only if they want to lie, both registrar and VC. Me, I will fear God. I will not fear any man. That is the verbal communication we had.
You have answered. After serving for a year again, my lord, after serving that a year, you're supposed to spend another 6 months before you can resign or tender resignation or pay in lieu of that 6 months.
Yes, let me tell you. Yes, they stopped salary. They kept on indicting us for investigative committee.
That is what
we don't know where we are. And we asked somebody, we asked our lawyer to tell them that they have not given us a reply. So it's a sort of indictment. And that is what is happening now. Kept on writing letters so that they can use this against me. Yes, it's more than 6 months. I resigned November 14 because the letter kept on coming. They didn't answer me. Which a year?
Yeah, you have option after 6 months to leave or pay.
Yes, I did pay for them. I paid for them because when they wrote us, yes, they asked for the money, and I wrote them. They are owing me salary for 2 years, and that of the remaining something. I said they should do subtraction and addition. That's the question. I paid to them. I told them to remove from what I have with them and pay me my balance. I told them. When they are owing me, how should I now pay in lieu again when I have money with them?
That's not for me. That's not for me. That's not for me.
Any examination? So what do you do?
What was the payment? We asked that if the witness is discharged.
That's what we claim, and is that the case for the claimant? Claimant's case is closed. CW1 is discharged from the virtual proceedings and can leave the meeting. Prof, you can leave the meeting if you so like. What is the position as it is now? The position is for you to open your defense.
Hello, sir.
Yes.
The
We want to raise your case on their own.
hello.
You want to raise your case on the case of the claimant?
Not at all.
Okay, I thought you want to raise your case so that we can now do a live.
Thank you, Malo.
Yes.
Hello. We go by the issue of this case, and for convenience of the court and the some of them they are saying they are unable to serve. This matter, we prefer the fence to be in Abeokuta, just like the other one, because part of them they are not well. That's why they cannot come for the next one that we mentioned. They have only one. Okay, I don't know whether it is partial work or not. So apparently, my lord,
so you want to open your defense. You are now asking for an adjournment.
Yes, but
so the matter to be taken in Abeokuta.
I'm very
simple.
That's it. And judicious. Thank you, my lord. Very small. Very small. That's why my lord is there for us. My lord has pouched it. Thank you, Lord.
Diary.
Yes, both his mic. Okay, he's back. Please unmute yourself so that we can hear you.
Okay. Good
On
morning,
your
sir.
mic. Okay, very well.
Yeah, good morning.
My
Yes,
lord,
sir.
the claimant is present. Defendant is represented by Mr. Ogunbanjo. What? Mr. Ogunbanjo Ololade, Deputy Registrar. Deputy Registrar of the defendants.
I normally as King Boyo. I feel of Gaja and Rebel.
With profound respect to my Lord, Adetunji Moraino. My Lord, I appear for the defendant. I appear with T.E. Ogunbanjo. This is
Are you ready? Yes, I'm ready. Yes,
Yes, my lord. Mr. Kazim, are you Christian or Muslim?
I'm a Muslim.
Muslim.
Yes, sir.
All right, you repeat after me.
Okay.
I, then mention your name.
I, Ajayi Kasim Olusomi,
Swear in the name of Almighty Allah
swear in the name of Almighty Allah
that the evidence I shall give
that the evidence I shall give
in this case
in this phase,
shall be the
in this
truth,
phase, shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me Allah.
So help me Allah.
My lord, the witness
Thank
swore
you.
with Holy Quran.
Professor Kazim, please
Yes,
tell
sir.
this court your name again. Okay.
Yeah, my name is Kasim Ajayi Olusomi. I live at number 3, Ijari Complex Road, Ijari, Ijebu-Ode, Ogun State.
What do you do for a living, sir?
Then, what did you say?
What do you do for a living, sir?
I am a lecturer, and I work with Tertiary and University of Education for 17 years. Yeah.
Do you remember making a witness statement on oath in respect of this suit?
Yes,
on
sir.
the 17th day of May 2024?
Yes, sir.
Take a look at the document being shown to you.
Yes.
That is said witness statement or not?
Yes, yes, sir.
You wish to rely on it as your evidence in this case?
Yes, sir.
The witness statement on court. On the 17th of May 2024, having been identified and adopted by the witness, is taken as evidence in proof of everyone in this case.
As the court please.
Yes.
In your evidence before the court, already adopted?
Yes, sir. Okay, thank you.
You refer to about 20 documents.
Okay.
Specifically, you refer to offer of employment dated the 21st day of December 2005.
Okay.
Please just be looking at your screen
Yes.
and be confirming these are the documents.
Yes, yes. Yes, sir.
They referred to a letter of confirmation of employment dated the 11th of September 2008.
Yes, sir.
You referred to a letter of promotion dated the 25th of March 2010.
Yes, sir.
You referred to a letter of promotion dated the 3rd of March 2014.
Yes, sir.
You referred to letter of promotion dated the 30th of September 2016.
Yes, sir.
You referred to another letter of promotion dated the 20th of September 2019.
Yes, sir.
refer to another letter dated 30th of August 2023.
Yes, sir.
Refer to another letter dated 18th September 2023.
Yes, sir.
Apologies, sir. I just forgot. I made a mistake, sir. There's an additional witness statement on oath filed by the claimant.
Additional statement of
Yes, sir. Yes. Hard copy. Hard copy. You referred to an application for leave of absence dated the 28th of September 2023.
Yes, sir.
And you also refer to a letter titled Unlawful Appointment Outside the University, dated the 10th day of October 2023.
Yes, sir.
You refer to another letter dated the 12th day of October 2023.
Yes, sir.
Then you refer to mails, a letter of someone inviting you to face disciplinary action.
Yes, sir.
This is the said mail.
It's not May, October. The first one came in October.
Mail.
Yes, sir.
You refer to letter of voluntary resignation of appointment.
Yes, sir.
Dated the 15th of October.
Yes, sir.
This is the said document.
Yes, sir.
They refer also to another letter dated the 4th December 2023.
Yes, sir.
Is that the said letter?
Yes, sir.
You also refer to Vice Chancellor University of Education condition for service.
Yes, sir.
That is a document.
Yes, sir.
you referred to a solicitor's letter dated the 12th day of December 2023 and 29th day of January 2024.
Yes, sir.
This is the one dated the 12th day of December. And the second one,
yes, sir,
dated the 29th day of January 2024.
Yes, sir.
He also referred to a letter dated the 20th of February 2024.
Title. Yes,
What
sir.
is that letter?
Title, sir. Yes, sir. I've seen it.
Then you refer to a letter of dismissal from the university dated the 2nd day of April 2024.
Yes, sir.
Is that the said letter?
Yes, sir.
You also refer to a letter.
What is the title?
Yes, just a moment.
Okay.
You also refer to a letter dated the 28th day of September 2023 that is headed
Yes, sir.
notification of intended joining outside the country.
Yes, yes, sir.
It's dated 28th of September, my lord.
Yes, yes.
I think it's number. My lord, it's number 10 on the schedule of this.
Number 10, notice of protection.
Yes, yes.
Outside the country.
Yes, my lord.
This was earlier not mentioned.
Yes, my lord. Sorry.
Now we have come back to it. Is that the data?
Yes, my lord. That's the data.
Anymore?
And the last letter dated the 15th day of April 2024. Is that the said letter?
Yes, sir. Yes, sir.
You also sign a certificate of compliance.
Yes, sir.
Is that the said certificate of compliance?
Yes, sir.
Although we seek to tender all the documents.
I think when the original form. In original forms, the ones that we sent, sorry, the ones that we sent, or that are eventually sent to the it's a bit of that very It's a bit of that very the ones that some are computer generated. Those are status change. Why don't you leave the witness now to tell me which ones are computer generated and which ones are show it to him where you can eliminate yourself from where you are by telling the court that some of the documents of people are listed their first. Make the job idea and easier. I thought we had computers. Having the certificate of compliance, you can always do that. You can identify those ones that are computer generated ones and inform the court so that I can have it on my record. Yeah. September number 9 and number 10. Number 9. Yes, sir. Then letter dated 10th October. Is this that's number 11? Then letter dated 12th October. This one, 12. And number 13, name and letter following the 19. And number 14, letter
letter dated 15th October 2023. And the letter dated 2nd April 2024. Number 19. Yes, sir. Those are the people that are yes, sir. 3 and 4 letters. Yes, ma'am. Letters, ma'am. Yes, ma'am. No, not photocopy. They are copies of letters. Yes, copies of letters sent to the finger. And the last one is a photocopy. The letter sent by the finger. Hello, we seek to tell us.
Hello, I've not seen the document. Sorry, my lord. Lord, I'm coming. Hello, sir. I will not be objecting to 1. Document mark number 1. Listed. Number 1. Yes, my lord. Number 2, my lord. Confirmation of appointment. Number 3, letter of promotion. Number 4, letter of promotion, my lord. Dated 3rd of March. Number 5, letter of promotion dated 30th September. Number 6, 2018. My lord, okay, I'm taking the one that I'm not objecting first, then I'll go back to one that I'm objecting and I will give reasons for the reason. My lord, it's almost finished. I think 2 or 3 more. 2 or 3 more, my lord. Number 6, yes, my lord. Number 7, number 8, number 15. Number 15, staff of condition. No. Yeah. 1 to 8. 16. Yes, my lord. 1 to 8 and 16. My lord, I'll be objecting to the activity of number 10. Right? Yes, my lord. 2. Yes, my lord. Yes. 10. After. We are not objecting number 9. We are not objecting. No. Number 1. My lord, 1 to 8. We are objecting to number 10, my lord. Yes, we are objecting to number 9. Number 9, number 10. And my lord, there is the arrangement of the number here. Yeah. Okay, my lord, we are objecting to the remaining document. Yes, my lord. Yes, my lord. Yes, my lord. 10, 9, 10, 11. 10. My lord, we seem to have 210, but we are objecting to notification of intended journey outside the country. Yes, my lord. Yes, my lord. Yes, my lord. Okay. Okay, we should right. I've copied, my lord. I'm very much obliged. We are very much obliged. To save the time of relatives. We are very grateful. We are very much grateful. Yes, my Lord. Yes, my Lord. Address. Yes, my Lord.
Those are last day, no. Bokong Bonnie ruling argue. So the second one, allow the objection. You should pick it after address. The first one to take it but it consume time. Okay. Argument consume time. You argue, I reply. So consume time. You know. Yeah, I'm there. Yeah.
The document tendered by the claimant counsel and evidence through TW1, which specifically and without any objection to the one listed at number 20
Bueno, te da biscuit dan. Como te da biscuit. Mat.
the defendant's counsel having objection to the remaining document with the reservation of combating his argument with the address in the proceeding. I have no difficulty at this stage to admit the document tendered in evidence by the claimant's counsel. Accordingly, the documents are hereby admitted in evidence and marked as Exhibit C1 to C20, respectively. Defendant's counsel is at liberty to canvass his arguments as why probative value should not be ascribed to the documents in protest. On protest.
My lord. Very much.
Yes.
Yes. Professor, are you still there?
Yes, I'm still here.
All right. Do you remember deposing to an additional witness statement on oath? Also,
Yes, yes.
Case dated the 30th
Yes.
October 2024.
I remember.
Yes,
The
I remember.
to additional witness statement on oath dated or on
30th October
30th October 2024.
2024, my lord.
Yes,
Yes,
yes.
sir.
You wish to rely on same so?
Of course, yes.
Which I hereby adopt, yes, as my evidence in chief as well.
Thank you, sir.
What do you want this court to do for you, sir?
I want the court to use all this evidence, to judge my case as being claimed.
He said he urges the court. What do you say, witness? He said, okay. You ask the court to do what?
To give me judgment on the case as per the claims.
Yes. Any other thing? Any cross-examination now, or you want to take an adjournment?
Hello, sir. What an adjournment.
Do you concede to the application for the adjournment?
Hello, sir. I need maybe a directive for your lordship, or I need a guidance from your lordship. Please, my lord, sir, we want to open this one, and the other one, we want to adjourn it. The other one for defense, we want to adjourn it for Abeokuta. I don't know, my lord. I don't know the disposition of the
This
court.
want to be adjourned
We want to take this cross-examination, my lord.
now?
Yes, my lord.
Yes.
And there is another one pending, my lord, for defense. We'll be begging your lordship for adjournment, or when we read them, my lord.
Yes, so that now, whatever case that is adjourned for it to come up in Abeokuta is coming up for.
All for defense. 3 of them, my lord. Anyone, my lord. I don't need disposition.
We can proceed.
Yes, my lord. Thank you, my lord.
Yes, but then you should be timed as well. You can see the time is already in the afternoon. Very seriously. You can take your 20 minutes. Some of the questions, are questions that are so related with documents that will only need your attention at the stage of address. But you tend to bother the witness with so many questions.
Okay.
You cannot change the position of the document no matter what it
As
says.
it covers, my lord. As it covers, my lord.
It is 10 minutes to 2. You can stop at 10 minutes past 2. Yes. That is the reason why if you lead somebody in a matter, and if you are bogged down by nature, then the other person can take over.
And because
busy.
And now you are evidence of appearing somebody, a capable body, capable any friend.
Nature is fighting you, you have to succumb, and the other person will take over from where you are. This is a very liberal court. You can step out. Yeah.
Hello, your lawyer says you. Okay.
So cross-examination.
My lord, sir.
You will stop at 10 minutes past 2.
I'll stop this, my lord. Professor Ajayi, are you there?
I'm still here.
Yes, sir. You have said you have worked with university, that is Southern University, for 13 years.
Yes, sir.
13 years?
It's 17 years, sir.
Yeah.
Yes.
Where are you presently?
I am at the Gambia for now.
Okay. Gambia. It's in Gambia for now. It's in Gambia for now.
Yes.
Tertiary Investor of Education granted you an employment based on their laws.
Yes, sir.
Yes.
That is after your application, after you have applied. You are granted sabbatical leave to Gambia after your application.
Yes, sir.
Yes.
The university can refuse the appointment, can refuse the application.
They can review it.
The defendant may refuse the application.
They refuse that application.
Which of the applications, sir?
The defendant, which I'm saying defendant, I mean university. They have
No,
your application for leave. That your application for sabbatical leave. The university, the defendant, can refuse it, may refuse it.
So you are saying the defendant had the discretion.
Yes, my lord.
Well, I don't know of that, but they have not reduced my own.
Okay.
Yes.
Yes, my lord. You are granted that sabbatical because you are a professor. You are in a professorial cadre.
Yes.
Yes.
When you are granted that sabbatical, you sign an undertaking with the university, with the defendant.
Not at all.
Okay.
Yes.
When university grants you a sabbatical leave, after that sabbatical leave, you have to come back to the university and serve the university.
I was not aware of that.
It's okay. Jesus. Yeah.
Yes.
Are you aware of that university has senior staff condition of service exhibit?
Okay. Of course, yes.
Okay. Exhibiting. Exhibiting. No, you don't want. Eh? Document mark 16, my lord. Exhibit.
Exhibit C2.
I'm very good, my lord.
This is C2.
C16.
C16.
This one. This one.
Yes.
Yes.
Okay.
Please give me the. Thank you.
Yes.
There are procedure governing sabbatical leave there, application and follow-up of sabbatical leave. There are procedures in that exhibit C16. That is the staff and conditions.
Yes.
Okay.
Yes.
Yes, my lord. You enjoy your sabbatical leave between 24th of March 2022 and 23rd of March 2023 in Gambia.
Your sabbatical was between.
Thank you, my lord. Your sabbatical was within 24th of March 2022 and 23rd of March 2023.
Yes, sir.
Okay.
Yes.
But you resume back to the university on 21st of August 2023.
That was not true.
It's okay.
Yes.
I came back.
When did you resume back to the university? When?
Good. I resumed even before my sabbatical was expired. I came back to the university on the 5th of December 2022 to conduct the remaining examination for the students and to submit all the 11
December.
The court is taking you. Wait, the court is taking you.
I came back to the defendant on the 5th of December 2022, you said?
Yes, sir. To conduct examination for the remaining courses that I was taking during the sabbatical leave. And I marked and submitted the results during the December period. I also went to the VC with two of his sisters, Buki Sodiq, Mrs. Buki Sodiq.
That is personal. That is personal. That is personal.
To tell you that I came home.
Thereafter,
just to tell you.
Thereafter,
I came back.
Thereafter, you went back to Gambia.
After seeking permission from the VC and the registrar.
You went back to Gambia.
After seeking permission from them, I was with the
VC.
VC
Went back, Abi?
with two, of course, with two of his sisters.
No problem.
And the VC granted it with the registrar.
No problem.
Yes.
You apply for extension of your sabbatical leave with the university.
Did you?
Yes.
Did you apply? Did you apply
I
for
applied, yes.
extension of your
Yes.
sabbatical from the university?
Yes, sir.
Yes.
That extension was not granted by the university, which was refused by the university. The
That
university
application.
yes, my
That
lord.
was-
Thank you, my lord. That application was refused by the university.
That is not true. As I said, I came back in December. My sabbatical supposed to end by March 2023. By March 2023. But I resumed in December to come and complete the marking, to submit the results, and to also tell the VC and the registrar that I have been granted extension at the Gambia. So when I was going, the Mrs. Buki, Sadiq, and Funke Reshi, they were VC's best friends, and they followed me to him. And it was in their presence that the VC approved. And the major reason why they approved was because I handled 11 courses during my sabbatical, which anybody has never done. So I handled 11 courses along with the courses that I'm taking here.
I was given time.
Yes.
That's there's no meaning of that answer now.
Okay.
I was given time. Hello, sir.
Yes,
Prof.
Yes, sir. I'm with
I
you,
have to
sir.
stop you by now.
Thank you.
Yes.
If you are granted leave, sabbatical, you have to serve the university back for a year after your sabbatical. That's the practice in the university and elsewhere.
It wasn't so. And I was not even informed of that.
It's okay.
Yes.
You are aware of, by virtue of SB 15, that is staffs. Okay. By virtue of SB 16, senior staff condition of service. That is the procedure. By virtue of chapter 2, paragraph 214, 1. And
what procedure?
And I will explain to you. And 214.2 of that of SBC 16, that is the procedure.
Counsel.
If
Counsel. This is cross-examination.
My lord is baby.
If you want to ask any question in relation to the content of an exhibit,
yes, my lord,
don't you think it is proper for the document to be given to the witness to read it out for the court,
my lord,
so that you cannot base your question?
My lord, in fact, that's the let's say, he tendered exhibit C16.
Yes. He made reference to them. He made reference to it in his witness statement on.
Yes, my lord. Yes, my lord.
The document is tendered by his counsel.
My lord. Which means that he's relying both the counsel is acting for the witness. So which means he's relying on that document as if to say he has knowledge of that document.
In any case,
yes, my lord.
In any case, the conventional way of doing it
yes,
is,
my lord.
If you want to ask about the content of a document,
yes, my lord,
show the document to the witness, draw his attention. You are even helping the court by doing that, helping the witness. Because you cannot
because of the time. It's because of time.
In any
no
case,
problem, my lord.
But what is what doing very well.
No problem, my lord. No problem, my lord. I'm coming, my lord. Sorry, my lord.
No, no, don't. On 28th of September 2023,
Yes, sir.
you notify the university that you want to travel out of the country and was not granted again. You applied to the university that you want to travel outside the country, and that application was not granted again.
How will I
Confirm
know
that.
that it was not granted? How will I know that it was not granted? When the VC and registrar asked me to go and write the letter, and I submitted because they know quite well that I handled 11 courses during my sabbatical. So when they asked me to go and write letter, I believed and trusted them. So I wrote and I waited since that 28th till on the 9th of October before leaving Nigeria.
Okay.
So I believe they will still send it to me, and VC continue to give me the assurance that
It's
the letter
okay.
will be
I
sent.
have time. It's okay. It's okay. It's okay. I have time. You have answer.
Okay.
No problem.
What's wrong with the power? Register. What's wrong with the power? Are they going to put it on? Tell them that the court is sitting. Council, can we manage the situation as it is?
Yes, my lord. Yes, my lord.
Yes,
My lord.
go ahead.
Thank you, my lord. Thank you, my lord. Hello, Prof.
I'm with you, sir.
Yes, sir. Are you aware of a body called Joint Committee of Council and Senate on Staff Disciplinary Matters?
Yes, sir.
It's okay.
Called what?
Joint Committee of Council and Senate on Staff Disciplinary Matters. So we are.
What's his answer?
He's aware.
I said yes, sir. I'm aware.
Yes.
Are you also aware of a body called Staff Investigative Committee on Ethics and Discipline?
Yes, sir. Yes, sir.
Staff, my lord, Staff Investigative Committee on Ethics and Discipline. She said.
On ethics and
discipline.
Yes, sir.
Yes.
She said, send you an invitation to appear before them, but you refuse. That is, staff committee called Staff Investigative Committee on Ethics and Discipline. Sent you an investigation letter. I mean, a letter to appear before them for disciplinary action, but you refuse to appear. You fail.
What you should have asked them is, when do they send it? They sent the message to me on WhatsApp around 9 p.m. to appear the following day by 10 a.m.
Okay.
They sent it through WhatsApp around 9 p.m. on Thursday, and they want me to appear on Friday by 10 a.m. And the person who sent it, I communicated back to him that if people are aware that I am not in the country, let it be virtual and will attend. But they never called that virtual.
Okay.
And they never informed me of any other decision. And if you still want me
Court
to
is
continue,
writing. The
I
court
can
is writing. Wait for
Okay,
question.
okay.
The court is writing. Wait. I will
Okay.
have talked. The court is writing.
Yes.
Thereafter, you are sent. After that one, you are sent another letter to appear. You refuse to appear again.
Thank you. The
Yes.
letter was sent. You know, I've informed them that I am not in
Say
the
you are
country.
sent the letter. You are sent the letter to Abi.
They sent another letter on that 13th that I should come again on the 17th. And I have seen it that these people are just, calling for what is not possible. I asked them for virtual. Virtual is what everybody have been doing. And they refused the virtual. I have taught about 11 courses during my sabbatical. And I see no reason, if I can do it on virtual, I see no reason why they cannot arrange the meeting on virtual. So when I now saw that they are not ready for that, I resigned before the date.
It's okay. Then I can go.
Yes.
You did not appear.
Because he could not make it. He said he was.
He did not appear.
Yes. Yes.
You did not appear because you are already taking appointment in Gambia.
That was the fallacy in it. How did they know that I have taken appointment? If I have taken appointment, does that stop me from appearing?
It's okay.
That is not the issue.
It's okay.
Yes.
The defendant has a policy in Exhibit C16, that is by its procedure, that if a memo has been written to that effect, that if you fail to use your leave, it will not be extended further during outside your academic period. For example, you have accumulated leave. There's a policy, there's a memo served on you that you cannot use the leave thereafter if you don't use it during your academic session.
That is also a lie, because they are the one who granted it. And all the academic period, we have been very, very busy. We have been using all our time, and they are approving the accumulated one. So the only place where you can use your accumulated is when you are on sabbatical leave. And they have given it to many people in that order.
Of employment,
Yes. Incidentally, your time is off.
Hello, one last one. You are given, when you are given offer of employment, there are terms and conditions there in that offer of employment. Exhibit.
C1?
Yes, my lord. Yes, my lord. Thank you, my lord. There are terms and conditions of the employment of your employment in Exhibit C1.
Yes.
Yes, okay.
Yes, he said there are terms.
To confirm, yes.
Confirm.
Yes.
He wants you to confirm that there are terms of your employment in your Exhibit C1. That's appointment letter given to you.
Yes, sir.
Fine.
Yes, sir. Where are you going, sir?
No,
That's
fine, sir. I'm not going anywhere. I'm in Lagos.
So,
my lord, that will be all for her.
thank you. Any examination? The case of the claimant is closed. CW1 can step down and can leave the meeting. Defendant counsel, where are you now?
Hello, sir.
Claimant has closed his case.
Hello. Hello.
Yes.
We are this state applying for adjournment.
Open to them.
Open defense of defendant at appeal subject to your lawsuit.
Claimant.
And subject to your lawsuit confidence.
Is it what? Your application is granted as prayed. The case is adjourned to the 5th day of November 2026 for defense in Abeokuta.
I'm very much glad. Thank you for your patience.
Yeah.